process, please.
For now. Yeah,
so that I don't panic.
yes, no, don't panic, Chair. I'll need 30 minutes, less, maybe 20 from now.
That's fine.
Yeah, thanks. I'll try and aim for past.
That's granted.
Yeah, okay. So, Chair, and that's why I'm doing it like this, packing certain things so that they can be discussed at the right time. So that's the first thing, Chair. The second thing is that you personally said that the reason why there was a delay in this statement of Advocate or Professor Madonsela was because of delays which were caused by the Public Protector and her team. We just want to demonstrate that there's nothing further from the truth. And if you allow me, Chair, instead of reading from the letters, I'll paraphrase. So unless if there's, just to save time, unless if there's something specific, we'll then go to the letters. But let me just quickly paraphrase what happened, Chair. We, as you know, in I think November and December, made an application for Professor Madonsela to be called as a witness for the Public Protector. We outlined the areas where we needed her assistance in a letter dated 14th November 2022 and in another one dated 13th December 2022. Then what happened is that the committee ruled that that application would be successful. In other words, she would be summoned. But it so happened that without the knowledge of the committee, I suppose, she had written a letter objecting to this and the other about relevance. And at that point, the committee then, I don't know what's the best way to put it, but basically then hijacked our witness to be the witness of the committee. That's fine. We didn't complain much because the committee, the witness was going to be called anyway. But in that process of hijacking, then the scope of what we had required was narrowed. That's fine. Even that we thought we could live with because we would get maybe not everything we wanted, but at least some of it. But then what happened then, Chair, is, which is the part that you then blame the Public Protector for, is completely something that is totally uncalled for. Because the former Public Protector, at least, wrongly blamed us for having, I think the word she used was forbidden, for having forbidden the evidence leaders from consulting with her, which we had not done. And in fairness to the former Public Protector, she apologized in a subsequent letter for that. And I think the Secretariat clarified that was wrong. It was a wrong accusation. We had never done such a thing. And we accept the apology of the former Public Protector in that regard. And because all we did really, Chair, was to say to her, since originally you were called by us, we would like to consult. And as you know, we can't force her to consult. So, and she elected not to consult because she wanted only to consult with the evidence leaders because she said there was a tradition to that effect, to which we explained that that tradition doesn't apply here. This is an unprecedented process. It has its own rules, and there's no witness who has, at least until that point, who had not done a statement with one or the other party. Anyway, as I say, the apology was made and accepted. Then the former public protector wrote to us and said, this committee has confined her evidence only to CX. And we must indicate other areas that we're interested in. I suppose.
And Friede.
No, I'm doing this. Yes, she didn't say and Friede. Yeah. She said it was only CX. Yeah. Sorry, Chair. This was about 2 weeks ago, yes. But we did exactly what you are doing, Chair. We assisted her, for which you are blaming us. We then wrote back to her. At her invitation, she said, I'm only asked to deal with CX. And if there are any other areas, please indicate, right? So we wrote back to her, we said, no, firstly, you are wrong. It was not just CX that the committee has indicated. It was CX and Friede. But in addition, in response to your invitation, these are the other areas that we are interested in, seeing that you don't want to consult effectively. Yeah, I'm paraphrasing again. Yeah. And we listed those areas. Including issues which I'll deal with now about Mr. Siabi. You'll remember all the issues that were raised where she was specifically mentioned. Yeah. So we listed those areas. Now, then she came back and said, and we even in that letter we said, just as a matter of courtesy, we also want to indicate to you not just the Friede, not just the invitation, but also that there's something called the 7-day rule. So please, if you're going to be testifying on the 1st of March, the statement will be expected on the 22nd, I think, whatever the 7 days is. Well and good. The statement did not come on the day that it was due. She asked for an extension, which you granted. And the statement came on the Friday, rather on the Saturday, sorry, the 25th of February. So how that becomes the fault of the public protector or her team, when all we did was A, to assist, B, to indicate, to respond to the invitation by the former public protector, to indicate what other areas, and C, even to correct her that it was just CX, it was also Friede, is something that really is not just hurtful, but gratuitous. So that's how that delay happened, Chair. And therefore, we could not benefit from the 7-day rule. We could not even benefit from the other rule that allows us to prepare, for reasons that I will explain later, probably in the afternoon. And now, it was being portrayed here yesterday as if the public protector, I don't know, does not want the witness. How could she not want the witness to testify when she's the one who called the witness originally before she was hijacked? So that's another completely unfair accusation to the public protector. Then, Chair, you also went on to say yesterday that we were, I don't know what you called it, like a double delay. We were proposing that Mr. Matabuche must be subjected to some double delay because of the deferment the last time and any further deferment. But that was a completely unfair accusation as well, because actually what we were proposing, as far as Mr. Matabuche is concerned, was to bring him forward. So we're not proposing any double delay. He's supposed to testify on Friday, And we had asked for two things. We said, please bring him forward, make him earlier, not later, and call him on the 1st and 2nd, which is today and tomorrow. So how that becomes a double delay beats me. And the second thing we asked, as far as Mr. Matabuche is concerned, is to say that we think we'll need him for 2 days rather than 1 day. And that was not even addressed in the meeting. And the reason for that, Chair, is not because we want to delay, obviously, because we wouldn't bring a witness forward if we wanted to delay. We would defer them. But the reason for asking for a longer time is just simple. Mr. Matabuche is going to, it took us a day, we even struggled with that day to deal with Ms. Mkhwebane, who's only testifying about the rogue unit report. Mr. Matabuche is testifying about the rogue unit report and 3 other reports, CR17, Busasa, Friede, and Pillay. And from the experience of Monday, it was clear that we're not going to be able, if we couldn't fit Ms. Mkhwebane in 1 day when she's only dealing with 1 report, then it's not going to be possible to do the justice to Mr. Matabuche. Sorry. So sorry, Chair. Okay, I'm going to need more time, but not much more, Chair. So that's the second thing that you said in the meeting. And again, because we were excluded in the meeting, we couldn't correct you from doing those things, or even overlooking that request, or dealing with it one way or the other. So it was in that context that we wanted Mr. Matabuche to move to the 1st and 2nd, because we would have been bringing him forward and also catering for the 2-day request. Right. Then, so Chair, then you then allowed yourself once again to be misled by the legal services or secretariat or whatever they are. Because when we raised the issue of the other witnesses, that we said these are the witnesses that we intend to call. The 3 categories, these are the witnesses we intend to call. These are the witnesses that would ask you to please subpoena. And then there are the other witnesses we're asking for you to recall. And you were told that, no, you discussed this thing in October and there's no need to revisit it. And that's what was the decision. But that misses the point completely, Chair.
You did say you will stay on issues on this witness. I wouldn't want to.
Yes, no. Yeah. I'm just, okay, fine. Let me just flag this one then. That point, the point that is missed there is we know we were here. We don't have to be told that the issue was dealt with in October or that it is part of the litigation. We know that. We are in that litigation. What we were saying to you was, due to the evidence that has now arisen, for example, Ms. Mkhwebane has placed Mr. Kotan squarely at the center of this. Mr. Matabuche has done the same. We were saying, due to that, we will ask you to make a fresh decision on that point.
I want to ask you,
Yeah.
You indicated correctly at the beginning that you'll park the other issues.
Yes, yeah.
So that the time that...
No. Fair enough, Chair. I accept. I won't develop the point, but I'm just, I think it's important to put that perspective of that perspective of where we were coming from with this letter, just so that you know that we're not crazy. We know that you made a determination in October. We know that I think you made another one in November or whatever. But we were saying, due to the obvious need for those witnesses. If you are fair, you could reconsider and say, now maybe we made that ruling. Maybe it was a correct ruling at that time, but now can we really not call those witnesses? And that's what. And you could have come to any decision, yes or no, doesn't matter. But to refuse to entertain the issue because you made the decision in October is just unacceptable completely. Then, Chair, as you correctly bringing me back into line to deal with the specific issues to do with this witness. The crux of the issues with this witness, Chair, is that, again, I don't know, the level of prejudice and bias against the public protector is just is difficult to stomach. This witness was supposed to come here today and tomorrow. Monday and Tuesday were not scheduled days for this commission, for this inquiry. And we would have had the opportunity, therefore, even if the statement was late for argument's sake, we would have had the opportunity to prepare on Monday and Tuesday, according to the original schedule. What the public protector did of her own volition to meet the committee halfway and to meet the request of the evidence leaders was to agree to interpose Ms. Mkhwebane for Monday and Tuesday. That was not the plan. You know, I don't have to go through the history. You know the story about Ms. Mkhwebane and the fact that she wanted to make a statement and so on. And we then compromised. We said, fine, so that the program is not affected, we will interpose Ms. Mkhwebane on Monday and Tuesday. And as a result of that, Chairperson, the time which we would have used to prepare for this witness was then used to assist the committee with this program. But no, that's the fault of the public protector. She's the cause of all the delays, and she's the cause of the seeking time to justifiably to prepare for the next witness. And all along, Chair, the unfairness in this is that you and your committee are fixated with the rigidity of the program. Yesterday, one listens with pain on YouTube, member after member is saying, no, we can't grant this request of the public protector to give time. Why? Nobody mentions the public protector. Nobody mentions the issue of fairness. No, it's all about, we have so many committees. We sit in so many committees. We have we have this burden. The committee has a program, and members have a lot of work. The person to whom you owe a duty of fairness is not even mentioned. It's all about you and your programs and your committees and your many committees and all that. When we are making a reasonable request to say, having been denied an opportunity to prepare because we were accommodating you, can we bring one witness, basically swap the witnesses. We're not saying don't sit, we're not saying postpone, we're not saying anything, we're saying swap the witnesses and accommodate us. No, that is just reason for us to be insulted. So Chair, that's really the objection that we raise, that to now blame the victim and the person who's been trying to assist you with your program and even assist the witness is just unpalatable. Let me just, the letter I was referring to, Chair, was the 23rd of February, 2023, I think that's Thursday, from Professor Madonsela to us. And paragraph 3, F of that, where it talks about whether the evidence leaders had forbidden her and so on, where we had said to her, it's false that our team has ever forbidden evidence leaders from assisting you with a statement. Please indicate to us who advised you of that non-existent fact. Then she says, I concede that I may have misunderstood why my plan to be assisted by the evidence leaders, her plan, on Monday, 20th February was scrapped. I apologize for communicating my misunderstanding as a fact and retract the assertion. And as I say, we accept both the retraction and the apology. But what we don't accept is to be insulted for it, as if it was our fault. And that's therefore the genesis of the delay, Chair, of why the statement came on Saturday. It's because of those two things. Her response to our response to her invitation, as it were. Yeah. In relation to the other issues that we did raise, and this is pertinent to what I'm going to say now, Chair. In relation to the issues that we raised to her outside of FRED and CX, she then asked a series of questions, and we responded to say, no, we're not going to answer. There's no point in having now the committee sitting in writing, in letters going up and down. We'll ask whatever questions, she'll answer them, or if she's not clear, she'll answer them here in committee so that you can rule whether our questions or her questions to us are to be answered. And I think that's where we left that issue of the extra issues. But the pertinent issue is not even that. The pertinent issue is that we were denied an opportunity to prepare, because the thing came on Saturday. Sunday we were traveling and preparing for Ms. Mkhwebane, and the last 2 days you all know. I'm now told that there's a new statement that has just arrived now at 10:13, an amended, edited statement of Professor Madonsela. Well, I didn't even know about that. In other words, now while I'm talking to you, I have not even seen it here. So, Chair, it is those issues that we want to raise for consideration by the committee, at least those that deal with this witness. The other issues, I agree with you. We're re-raising them and putting the context. You can deal with them in the committee at another time, or the issues about witnesses. But we demand to be given a response on those issues, positive or negative, rather than it being brushed aside as an October issue. But as far as this witness is concerned, what we are requesting you, Chair, is to consider the history that we have placed on the record, and at the appropriate time we will address you on the directives, on our interpretation of the directives. And let me say this, Chair, just so that it's clear. If we have no objection, well, subject to this thing of the new statement now, I'll ask for 5 minutes maybe just before you swear her in, or even after, just to consult on that. But subject to that, at least when we came here this morning, we had no objection to her being led, for example. As to what happens when our turn comes to question her is a matter that I say I'll address at that point, yeah. But now, maybe I don't know if you have the new statement. You don't? Oh, okay. How long? I'm told it's longer than the other one. 9 pages, which nobody has seen yet. So, Chair, I'll leave it in your hands. Maybe the 10 minutes might not be enough. Have you received it? Sorry, Chair. Sorry, Chair, I'm taking over your meeting.
No, I can see that.
I'm just,
And-
yeah, sorry,
and-
sorry.
and it's not going to be too often I allow you to do that.
No, sorry, Chair. I just wanted
quickly,
to clarify
Ms.
myself. Yeah.
Chair, I just needed to indicate that we would need time to just look, because I haven't had a chance to look at it yet.
Okay.
You have it.
I've just received it.
Okay.
Yeah, otherwise we'll send it to you.
That's
fine. Thank you,
And
Chair.
then
Can we then adjourn, Chair? Then when we come back, I'll then address you for a few minutes, one way or the other. But I think it's fair that at least us and the colleagues have a look at the new statement, because it actually might make everything I've said to be academic. Yeah.
Thank you, Advocate Mpofu.
Thank you,
I
Chair.
would have given you, you would have asked for 20 or so minutes. Giving you more than that. The 30 minutes you asked, actually 35. Thank you.
Thank you, Chair.
I think it's only fair that, yes, before that, Advocate Bauer.
Chair, can I just ask one clarification? The evidence leaders is under the impression that Advocate Mpofu is going to lead Professor Madonsela.
Okay, I'm going to.
Chair, can I address that so that we don't waste your time
Yes.
when we come back? I'm sorry, Chair. No, well, that impression is wrong from the evidence leaders. As I said, it's not, again, it's blaming the victim of the hijacking now. Yeah. Once the witness was taken over by the committee, then the rules are very clear that such a witness is led by the evidence leaders. That's why we wanted originally to consult with the witness so that we could lead her, but we can't lead someone who
You've answered the question.
Okay, thank you, Chair.
Advocate Bauer?
We can postpone that.
Chair, the witness was not taken over by the committee. So the witness, Advocate Mpofu asked for the witness to be subpoenaed. The committee agreed to accede to Advocate Mpofu, to the PP's request for the witness to be subpoenaed. In the course of that, the witness said, you don't have to issue a subpoena. I'll come willingly, pursuant to the PP's request for her to come. She then did not want to consult with him. They did not, and because of that, we did not consult with her because she was a PP's witness.
No, Chair, well, it looks, I'm sorry, maybe Ms. Bauer was not, doesn't have access to YouTube. I think yesterday every member said that this is our witness and we have called her and therefore the other rule doesn't apply, whatever. But no, it's fine. We'll sort that as well during the break there, Chair. Thanks.
No, before we make Ms. Nomkhosi Madonsela an orphan.
Nomkhoso.
So, because I can see now, she's now become an
Orphan.
an orphan, even before she takes the stand. I will just as an apology to everybody, including our witness who will be introduced, for the delay in this proper or actual start. We will take a break. I think it's only fair that I was in any case going to do that after we would have spoken, but it's fair that we accede to that. We'll take a quick 15-minute break and be back here at just about 5 to or so.
Chair, can you make it 1:15, please? It's 1:45 now.
Okay. So
if I have to read a
take
9-page
a
statement.
15-minute break and be back at 11, at least.
If it was 15:11, but can you make it more? I need to read that 9-page statement,
Okay.
among other things.
Is
Slightly.
that in order, members? Can we do that? There's an extra 15 minutes request for a break. Come Advocate Bauer. I'm giving you an opportunity. Okay. So, I think I think the 15 plus minutes would assist. So I accede to the second request, or we'll resume at 15:15. You must be very lucky today.
Yeah, no, I'm shocked. Thank you, Chair.
Recording stopped.
that the changes made are made on the version of the 25th, which was the version that was originally submitted to the committee. But there appears to be another version without the changes, the content of which is exactly the same, which is the 28th. So I haven't received that clarity, but in terms of the content, I can confirm that the content isn't affected at all. It is just cosmetic changes. Thank you, Chair.
Thank you, Ms. Ibrahim. Now go to this side. Over to you, Advocate Mpofu, and then thereafter we can invite the members. Thank you.
Chair, sorry, I'm just making a note of your earlier request. It was about the, take away hijacking. It is the adoption or otherwise of the witness. Okay. No, before I come to that, Chair, if I can just address this issue of the statements. Well, firstly, we welcome your ruling about not proceeding with the witness today, because the confusion is just immense. And if it makes you feel better, I retract and apologize about the 9 pages. But that's part of the confusion that was created. The 9 pages comes from the fact that, as Ms. Ibrahim indicates, we received, while I was talking to you, there's 9 pages which had the old statement and the new statement. But it's worse than the question of the new statement, Chair. And I'm hoping that the break will assist all of us. Either there must be a completely new statement so that we don't have to be having this kind of technical debates when she comes, or something. Because what is happening now is actually not just confusing, it's actually probably illegal. Because not only has Professor Madonsela changed her statement, there are now 3 versions of the statement. Version 1 is the one that you and I received on the 25th, which had some handwritten changes. Version 2 is a version where she put those changes that Ms. Ibrahim spoke about by hand, without changing the date. We don't know when that version was done. Version 3 is the one that arrived this morning, which was commissioned yesterday, and that makes it even worse. And it seems to be that that version 3 is now the typed version of version 2. But there's something fundamentally wrong and possibly illegal about that, because that version says it was signed in Stellenbosch, but it was commissioned in North Riding, Johannesburg, which is a physical impossibility. So either someone has broken the law, either the deponent or the commissioner of oaths, or both. But all those will be, because of the break, I'm saying, Chair, that those issues will be clarified with the witness and, if necessary, with the commissioner of oaths or the police. So that issue will then take its own course. Yeah. Now, coming to the issue, again, Chair, in welcoming your ruling, hopefully that break will also get this thing sorted out as to who's going to call her first and so on. We probably would not have been able to resolve it today. But
I actually wanted to be clarified today, so
yes,
that we know, as we leave here,
we know,
who's leading,
so that we don't come back. No, I appreciate that. We don't come back and then be caught up in technicalities. I'm also raising it in that spirit. Now, Chair, the issue is this. At least I can taking everyone's bona fides on board, I can understand how this confusion has arisen. And I will refrain from using the word hijack. I think what happened is that, as I said in the morning earlier, we requisitioned the witness you adopted the witness as the committee in the sense that you, and then changed the scope in the process. At least that was our reading of it. Whether it's correct or not is another matter. Then the witness, unfortunately, caused even more confusion, because you said in one of your letters, Chair, you said to her that she must approach the evidence leaders for assistance. So it's either the witness or you who caused the confusion. You said in your letter dated 9th February 2023, you said, should you require the assistance of the evidence leaders to prepare a statement, kindly contact the committee secretary, Mr. Temigo Singoma, by no later than close of business on the 13th, and so on and so on. The evidence leaders are understandably exceptionally busy at this time, and the assistance is subject to you availing yourself. And, okay. So, again, that's why I'm saying, let's assume everyone was acting in good faith here. So I think then what then happened is that the witness, because of that, of what you said, then elected or accepted that she will be assisted by the evidence leaders. So when we wrote to her, still thinking she's our witness, to say, come and consult with us, she said, no, I want to consult with the evidence leaders. So that's where there was that hachi-pachi about who's going to consult with her. Fine. Ultimately, she did not consult with the evidence leaders, neither did she consult with us. She chose to have an independent statement. And I think this is a result of that. I'm not, without apportioning blame to anyone. Because one of the results of that, Chair, is that that's why we have this mess now of these statements. Because quite frankly, whether it was the evidence leaders or us, we are professionally trained. We do these things every day. So the statement would have been done properly, either by us or by them. At least as you know that. You've heard our statements from both sides here. So she deprived herself of that opportunity. And that's why we then had the delays and the statement coming on a Saturday and so on. But again, I'm assuming she was also legally advised and acting in good faith. But all that has now landed us in the mess that we're in, where, quite frankly, there's no statement before this committee, because this one is not a proper statement. It's not an affidavit properly defined. But I don't want to get into technical legalities here. So again, I'm hoping that will be sorted out amicably between us as colleagues and her, and find a way out of that little hole. That's done. The third issue, Chair, which I want to address is the issue of when then does she come back? Monday and Tuesday, which you are suggesting, I think we have a problem with Tuesday. We could do Monday, because again, those were not sitting days. But the most important thing, even if we manage to make a plan, and we'll talk to you offline if we do, about the Tuesday thing, certainly the issue of the PP statement, because the real reason why we were so nice and accommodating about this week to pack it the way it was packed is that we needed the time to do the Public Protector statement, obviously incorporating the evidence that would have come from Ms. Mviana, Mr. Matabuche, and the Public Protector. I can tell you now, it's going to be physically impossible to do all that in 2 days, like on in 1 day actually, which is yeah. So unfortunately, I know you like your program, but I think we, and again, we don't have to have that discussion here. We're going to need to find some way of accommodating that. Sorry. Yes. So that's the practical difficulty. there was even talk of doing it over the weekend, and maybe we'll have that discussion with the evidence leaders and see which weekend would be suitable, if assuming again that it will only take 2 days. Well, I'm assuming that the 2 days will remain intact. As far as Mr. Matabuche is concerned, yeah, it's a slight challenge, Chair. And in all fairness, much as we want to assist the committee, but really, I think there must be a realization that we're also human. And we can't be made to work like this. We suggested to you kindly yesterday, we wrote a letter and said, can you please have Mr. Matabuche today and tomorrow? You rejected that and insulted us in the process and accused us of wanting to make a delay when we actually wanted to bring him forward. As a result of that, we obviously then stopped our preparations for Mr. Matabuche, because even that suggestion to do him the following day was a major sacrifice on our part, because we were going to have to now work overnight to prepare for him. We didn't do that because you rejected our proposal. Now we come here and now you want to tell us at 11:45 that we must do Mr. Matabuche at 1 in an hour's time. That's just, I don't know what to even call it here. So I understand where you're coming from. You're also trying to accommodate us because we said we might need extra time for Mr. Matabuche. That I appreciate. But to do it like this is a bit insensitive. But having said that,
Yeah, if you can try and wrap up.
yes, thank you, Chair. Yeah, so that we don't actually get to 1 o'clock. Yeah. Having said that, Chair, I'm going to consult with my team and see if we can do anything with Mr. Matabuche today, even if it means finishing him later on or whatever. But we cannot be. He cannot be imposed on us. I think we can be requested to try and accommodate him, and we will, given the fact that we would have been busy with him now if we had been listened to yesterday. Yeah, so the 6th and 7th is a problem. The PP statement obviously gets affected, and the Mr. Matabuche issue, Chair, I'm leaving it back in your hands, but I'm afraid it's not, I don't think it's something you can impose on us. We will try and accommodate where we can. But
Just finally indicate you're leading Professor Madonsela, or you?
oh yes, sorry. That's the real issue you wanted to know. No, we're not. She can remain where she says that she preferred to deal with the evidence leaders, so they can have her. And yesterday the members claimed that she was the committee witness. You can also, the members' wish can also be realized.
Okay, you've answered my question. Thank you, Alfred Mpofu.
Thank you.
Maybe just before I give to members, just to clarify and correct 2 things. I summarized yesterday's discussions of the committee, and Ms. Madonsela, being the witness of the committee, was not part of that summary. So I really don't know where that came from. Secondly, you did make the point that you were excluded. You were not excluded. I indicated that the committee was having its own discussion, and that people were free to join with YouTube, but and whatever channel. But it was a committee meeting for the members to discuss their own in-house issues, and nobody else in that process who's not a member would participate. I thought I must clarify that, so that there's no exclusion from our side. Honorable members, okay, Ms. Ibrahim.
I'm sorry, Chair, if you'll just allow me to give some clarity on the question that I raised with Professor Madonsela before members come in, so perhaps that we don't waste time on that. There was an issue that the affidavit that was dated yesterday, as Advocate Mpofu said, stated Stellenbosch as the place of signature, but then stated that the Commissioner of Oath is based in North Riding, which is in Gauteng, as I understand it. I've now clarified with Prof. Madonsela that, in fact, she was with the Commissioner of Oaths yesterday in his presence and had it signed. This is his business address. Chair, I've just checked the regulations to the Justices of the Peace and Commissioners of Oaths Act, and it says, below the deponent's signature or mark, the Commissioner of Oaths shall certify that the deponent has acknowledged that he knows and understands the content of the declaration, and he shall state the manner, place and date of taking the declaration, and then there must be the full name and business address below, and she's now confirmed that that address is the business address. So I hope that clarifies that confusion.
Okay, yeah. Advocate Bauer, you had your hand up.
Yeah, I think the issue with the evidence leaders and Professor Madonsela, we do need to clear up. We had initially been asked to assist with Professor Madonsela's statement. We then had a backroom meeting on the 10th, which was the day after the letter had gone off. Certainly, as the evidence leading team, and I haven't listened to the recording at all, we had left that meeting, at least on our part, under understanding that Professor Madonsela was the PP's witness. We assisted them in providing the contact details in order for them to make contact with Professor Madonsela for purposes of arranging a consultation. That was after that letter went out, after which we had sought to undertake. And that is why, although we had scheduled a meeting with Professor Madonsela for the following week, we stepped back to avoid any accusations or inferences that we were now seeking to interfere with the evidence of a PP witness. It wasn't that, no, that was our view of why we didn't.
Please don't respond to him. Yeah.
Advocate Mpofu, I don't do this when you're at the mic. You can at least have the courtesy to not interject.
I'll just apologize.
Are you
If
doing
want
it
me
again?
what do you want me to do now?
I've not recognized you, Advocate Mpofu. Go
Thank you,
ahead.
Sorry, Chair.
So certainly, from the evidence-leading reasons, the committee had entertained the issues on the motion, and on the basis of evaluating what other witnesses we had, we decided that she was not. That what we needed to ascertain from her in relation to Vrede and CX, we could get from witnesses who were being called in respect of that and other matters. And we certainly didn't take the view that when we needed to put evidence before the committee, we needed more than one person to say the same thing. That is a waste of time and it defeats the purpose. So that was where we came from as the evidence-leading team. If the committee had said to us, this is a witness that we wanted to hear from, then certainly we would have gone out and done that. But it was on the basis of our interaction in the back room where it was made clear to us that we wanted to do that. The decision whether she wanted to consult with the PP's team and whether she wanted them to do her statement, that is the witness's choice and election. I was never told by the chairperson or by the committee that this was somebody we really wanted to hear from and you should go out and do the statement. When a name has come up in the committee, for example, over and above the list that we have put up, we've either explained why we haven't called the person or we've endeavored to see whether there was any relevance to the motion. Now that is an important fact because as evidence leaders where we stand now, I'm still not convinced of the relevance of Professor Madonsela's evidence to this inquiry, even based on the statement. So there must be some clarity because if you're going to say that to us, then I'm going to say to the committee, well, I don't see any reason why she should be called for oral evidence at all. Sorry, Chair, on the second point, there was an arrangement made with us and the PP's team in respect of the PP's written statement. We had worked out the schedule that the proceedings would be done by Thursday. We're a day later on it, and that the statement would be provided by next Wednesday in order for them to then have had the Friday, the Monday, and the Tuesday for purposes of finalizing the statement. The statement was then going to come on the 7th for the PP to commence evidence on the 15th, on the understanding that Advocate Mpofu would take a day of next week to prepare for his hearings on the 13th. So I am taken aback, given that the understanding was that they would be busy with the PP statement on the 6th and the 7th for purposes of submitting that to the committee on the 7th, that the PP's team is now unavailable for a hearing on the 7th.
Chair.
Okay, I think on the committee will deliberate on this issue of who leads or who cross. It should not be a difficult thing to. I would not want it to be a to and fro thing. We will.
Okay,
We'll make that decision. That's okay. Go
Thank
ahead.
You, Chair. Thank you, Chair. Sorry, I'm sorry to. I don't intend to waste your time. Well, apart from the unfortunate remark that is made towards the end. Firstly, I never said the PP's team was not available. I said we have a problem on the 7th because one of our, or some of, anyway, I don't have to get into details, but I didn't say what is alleged I had said. But even if I had said it, the point I'm making, which I hope will not perplex Advocate Bauer very much, is the fact that even assuming, and I said I was going to make a plan, so I don't know why she's going on about that, but I was saying even assuming we do that, we would then be left with 1 day within which to make the statement, which is just completely unreasonable, even to the perplexed evidence leaders. The issue, Chair, is that, you know, I don't know, it's unfortunate that we have to do this like this. The Advocate Bauer tells us that she doesn't even think Advocate Madonsela has any relevance. The first time Advocate Madonsela appeared on any witness list was on Advocate Bauer's witness list, which they give to us in July. And I don't know why she was relevant in July last year and appeared on their list, and now suddenly she has become irrelevant. So it's just completely disingenuous to now want to backpedal on that point. So that's the first thing. The second thing, it is not true that because of our meeting on the 10th, that negated your letter on the 9th, Chairperson. Because the letter on the 9th, you said the witness must contact the evidence leaders, presumably on some understanding with them. Advocate Power is quite correct that in the meeting of the 10th, we willingly said, we are the people who have called her, and therefore we will assume responsibility for her, like we did with Ms. Mviana, like we would do with any other witness that we have subpoenaed. I don't want to repeat what I've already said. What then followed is the fact that the witness herself wanted to consult, probably either following your letter or of her own accord, and I don't want to speculate what was going on in her head. But she wanted to consult with them. She wrote to us on the 20th of February, 10 days after the meeting that Advocate Bauer is talking about, and said, regarding my willingness to prepare a statement for the committee, I'm willing to do so, and as indicated to the committee, prefer to do so independently. That's the first thing. It is my understanding that witnesses at an inquiry, like witnesses in the Public Protector investigation, sought to help to locate the truth, wherever it may be hiding, she says at her paragraph 5, and not embedded with any party. That's what she says. The tradition, as I understand it, is that the evidence leaders assist with preparation of statements, which I presume, among other things, ensures relevance and admissibility of evidence. She said, having been advised that your team has forbidden evidence leaders from assisting me with my statement, I've decided to prepare the same on my own. I've explained that we told her that that's false. We never forbade. She apologized. That's water under the bridge. So let's put that aside. But we cannot detract from the fact that 10 days after what Advocate Bauer is telling us, the witness said she preferred to consult with them or to go independent. Ultimately, she went, quote unquote, independent with the results that we now know. And then she said at paragraph 8, Chair, kindly note that from the committee's side, this is where you come in, it appears that I only needed to share what I know on the CX investigation, spelled S-I-E-X, investigation. This is where we told her that it's not spelled as S-I-C-X, it's spelled as C-I-E-X, and there's also Frede on top of it. I've already given you that history. So it was this letter of the 20th, which is only last week, that this issue arose. We then wrote back to her and say, okay, if you want to go independent, fine. But please be reminded that there's a 7-day rule. I've already told you what happened next year. So let's just be factual and correct and not
Thank you.
change.
Thank you. Honourable members?
I have a point of correction that I think is important to understand in the context of what the evidence leaders had provided, as far as the witness list is concerned. I think it's correct to say that the evidence leaders provided the witness list on the 1st of July, on which Professor Madonsela's name appeared together with 28 other names, not all of which was called. The preface to the witness list was stated as following. This list is currently confidential and is only being provided to the legal representatives of Advocate Mkhwebane. The evidence leaders seek to keep the identity of witnesses confidential until such time as the evidence is provided to the committee. If the evidence leaders determine that the written or oral testimony of a particular witness is not required for the proper assessment of the motion, they may decide to not call such person unless otherwise directed by the committee to do so. The above witnesses may either be called to provide written or oral evidence or a combination of both. The names of the list appear, and that's it. The rest is not relevant. So I think the presence of Professor Madonsela's name on the evidence leaders witness list was qualified.
Honourable members, your take on, I've placed some issues here. You've had the responses, counter responses. If I may hear your voices on the matters. Honourable Nkosi, you will start. Any other member? Mailam. Honourable Tlakude. Maneli, thank you. Those would be the 4 names. Honourable Nkosi.
Thank you, Chairperson, and is it still morning? Good morning. Afternoon. Firstly, Chair, let me apologize. I have a meeting that is starting at 12. I had forwarded the apology earlier, so I will not be able to sit through. Okay. But on the issue, I think it's clear that we facing a dilemma we faced when we decided to issue the subpoena on relevance and on what issues. Remember that we were persuaded to issue the subpoena because of the belief that her evidence was going to be relevant to the issues, particularly on CIX and whatever. And then we agreed to confine that to those issues. But from what we hear now from both sides, it's clear that nobody thinks that she is relevant. Her evidence is relevant. And I'm prepared as the committee to say, no, look, we can take a decision not to take her because nobody wants to lead her evidence. It's not relevant. If the evidence leaders say she's not relevant, they don't want to take her, then we don't need that evidence. We said so. We also said at the time that it's important that when we come to this witness, all issues related to her evidence should be resolved and sorted out before we even appear here. But we're back at that. So my view, Chair, is that I agree with your summary and how you want her to appear. If the issue of the relevance of her evidence, including the statements and clarifications of the statement, is not resolved either way, then we do not have to call Advocate Madonsela. If it is resolved, yes, true, we will call her and then she'll come and present. But if really this issue is not resolved on who or on whose behalf she does so, then I'm prepared as a committee to say, look, in any way, we didn't want to subpoena her. May I leave, Chair? I'm not disrespecting you.
Thank you, Honorable Busisiwe Mkhwebane. Honorable Mailam.
Thank you, Chairperson. And Chairperson, let me apologize for not putting on my screen. My Wi-Fi is a little bit dodgy today. Chairperson, I just want to address one issue, and that is the fact that it was at the request of Advocate Mkhwebane's legal team that Professor Madonsela was subpoenaed. To put the burden on the evidence leaders to now lead that evidence is frankly, in my opinion, unfair, because they have not said or have not identified any evidence that they wish to lead. The person or people who wanted to call Professor Madonsela were the Public Protector's legal team. So the burden should be on the Public Protector's legal team to lead that evidence and then allow Advocate Bauer to then cross-examine. That's my opinion. Thank you, Chair.
Thank you, Honorable Mailam. Honorable Tlagode.
Thank you very much, Honorable Chairperson. Morning, evidence leaders, the PP's legal team, and Professor Madonsela on the virtual platform. Oh, it's a good day. Honorable Chair, I want to fully agree with my colleagues. Yes. Professor Madonsela was subpoenaed because the PP's legal team wanted her to be subpoenaed to appear before the committee. So now, because no one wants her to come, I mean, the evidence leaders and the PP's legal team, they don't want her. So as a committee, I want to suggest that we adopt her, that Professor Madonsela come and address us as a committee so that we can see what we'll get out of that. No one wants her, we want her, because we want to understand the subpoena and now no one is owning her. So if Professor Madonsela is available, then we will have her, so that we can have clarity, we can get clarity on those issues that they wanted her to come and clarify. The CX matter, the Friede dairy farm, we are interested to hear that. Then with regard to the statement, I think Ms. Ibrahim said that the statement doesn't change the content. It's only the cosmetics of it, which I understand can be corrected, because she said the statement doesn't change the content. So it's fine. They must correct that and we move forward. Then with regard to Mr. Mataboge appearing before the committee, we discussed this matter yesterday, that we will have Mr. Mataboge on Friday. Our understanding as a committee is that you don't prepare last minutes. We would have expected that the legal team would be ready.
You can look through the chair, look,
Yes,
so that you
would
don't.
be ready with the witness. So that is our take. Maybe I took it for granted that they are overworked or not, but that is how we do things, Tina, in Parliament. That you know that you have 3 meetings tomorrow. After the last meeting, you go home, refresh yourself, and start preparing for those 3 meetings that you are going to have. So that is our expectation as a committee. That so they'll respond for themselves. You will respond when you are given a chance. Then we accept your summary, Honorable Chair, that the statement of the PP will have it on the 9th. Then that is acceptable. Thank you very much, Chair.
Thank you, Honorable Labode. Honorable Maneli.
No, thank you, Honorable Chair. Greetings to members, the PP legal team, and Prof. Madonsela on the platform. Chair, I want to start by agreeing with, firstly, the summary you made yesterday, which you've clarified again, that's still correct. The second point, it's on what you've made as, again, the summary of the discussions of the break and how you're guiding the committee going forward, including the request for us as members to still be prepared to hear the other witness, which the PP's team, as they correctly said, they would have asked for that, Mr. Mataboge to come even earlier as part of assisting the process until this discussion we had yesterday. And I want, as I say that, Chair, to indicate that we are discussing because we needed to consider that is put before us. And that break was necessary because we were entertaining what is before us. And that allows us then to review the positions we may have had, like that of continuing with the witness to be sworn in. And I'm using that wording, the witness to be sworn in, that we're unable to proceed in that regard. So it means we would have listened, so changing the view in that score. And therefore, there's no problem in looking at the issue of Mr. Mataboge on availability and going forward with that. Not just on the basis of time, Chair, that's being chased, but as I say, on the basis of looking at whatever is presented before the committee and applying the mind on that. Now, coming to the point of the witness to be sworn in, Chair, it's unless I didn't understand it. The first thing is that the committee has not come with this witness. We discussed the matter at the request of the PP's side. And that discussion was meant to assist them to be able to proceed. As I say, Chair, it's unless I didn't hear the PP's side from the legal team has now made it clear in answering you to a question you've posed that they are not having that witness anymore. It's the witness that the evidence leaders or the committee, as it discussed yesterday, those were the references made, that it's with the committee. And I'm saying that being the case, Honorable Nkosi then is correct, because we've never considered it to be a witness. That witness was not considered by the committee. The committee would elect to take the statement that gets received. On the basis of that has been received, you conclude then that there would be no reason really to call this witness, as those that requested to have that witness would no longer be interested in having that witness. Because if they are interested, it will be their witness, and therefore would lead evidence in that regard. So in this case, we don't have that witness. And I would say, Chair, it's also not about the time. It's about matters as they are presented before us. Probably the issue about time would be that in the absence of that witness coming on Monday and Tuesday, it is only extra days for preparation on the other side, so that you are able to get the statement. I'm saying this without taking away the extra 2 days you said that gave up until the 9th, so that there is preparation in that regard, Chair. So I just thought I should agree with Honorable Nkosi, so that it's not like we wanted the witness. The committee only discussed because there was a request on the table. Thank you.
Thank you, Honorable Maneli. Honorable Xolangwala, I think you are the last one. That's the last hand I have. I have not seen any other hand. Or Sukas. Honorable Ngola, over to you.
Thank you very much, Chairperson. Chair, this is not the first time we are discussing the relevance of the evidence of Advocate Madonsela. If one would recall, Chair, after having received the letter from Advocate Madonsela saying she does not believe that her evidence will actually be relevant to the work of the inquiry, the committee has made a discussion around this matter on the relevance actually of the evidence to be adduced by Advocate Madonsela. And Chair, in that discussion of the committee, we agreed that not only is the affidavit ought to be deposed by Advocate Madonsela, we qualify as the only evidence. We have said, Chair, we shall remember that since the resumption of this inquiry, we have had witnesses making serious allegations of altering of information in reports, particularly in respect of the Fred Daily Farm and the CIX report. So that forms part of the basis at which we have said Advocate Madonsela still remains relevant to the work of this committee. Now, we have said we're going to, as the committee, find thematic areas where we think she will be able to assist the work of the committee, which in the main was Fred and CIX. Now, the affidavit she deposed speaks unto those particular reports. I doubt, Chair, from where I'm sitting, that her relevance has now diminished. We see that there is evidence leaders, the legal team of the Public Protector know that witness is theirs, no, is us, and all those things. But I think Honorable Lakude is assisting us going forward. In that, if there is this dilemma, we as the committee remain with a conviction that the evidence of Advocate Madonsela still remains relevant. And therefore, we still are willing to hear the evidence from Advocate Madonsela. Now, we're taking a decision as the committee that we're taking her as the committee witness. It's a suggestion. that I want to agree with Honorable Dlakude, but let's take Advocate Madonsela as a committee witness. Then if Advocate Madonsela is a committee witness, that therefore means the evidence leaders are supposed to prepare the witness on behalf of the committee. Now, Chair, if we check the program that was adopted by the committee, we're supposed to have the last day Friday, then resume on the 15th of March. So if the chair, the secretariat, the evidence leaders, and the legal team of the Public Protector can do the backroom arrangement and find a suitable date in between Friday and the 15th of March, where whether they find one day or two, where Advocate Madonsela must appear before the committee. I'm saying this, Chair, because the allegations that were made against Advocate Busisiwe Mkhwebane of having altered evidentiary material in these particularly two reports was done in the public discourse in this committee. So we need that kind of information, whether to confirm those allegations or to rebut those allegations. So I want to propose, Chair, that we follow the proposal by Honorable Dlakude that we must have Advocate Madonsela. If indeed we've got various convictions as committee members, the neutral ground we can reach is not to dismiss evidence, but rather say we receive, we'll take the evidence as a written statement, as we did to Advocate Malunga. But that must be the neutral ground, Chair, only if this proposal that was made by Honorable Dlakude does not see the light of day. Thank you very much, Chair.
Thank you, Honorable Ngola, and your neutral grounds. Honorable Sukas.
Yeah, Chair. Good morning, Chair. Good morning to the committee. I share a different view, and I'm in support of what was said by Honorable Maneli as well as by Honorable Nkosi. The context is important because the context was that the previous public protector was going to come and testify or bring evidence, or was needed to bring evidence because the request was coming from the PP legal team. Now we have this situation where first we had the request for the witnesses to be changed for today and for tomorrow. And it is my view, Chair, that as a committee we discussed on Advocate Madonsela only because the request was that she needs to appear here as a witness. So I just want to support that view that if the witness is no longer owned or needed by the Public Protector's legal team, then as a committee, we proceed with the next witnesses that is before us. I think time is important. I have a total different view. I think time is important. Time is having an impact on the work of the committee in such that if you have members that has responsibilities as well, we need to understand the impact, not only on the witnesses, but on the committee as well. So within that context, it is important, I think. You cannot take time out of the equation, because with time comes cost, and with time comes as well the onus that's on the committee to, within a reasonable time frame, complete this process, Chair. Thank you.
Thank you, Honorable Sukas. The very last, you'll be the very last, Honorable Gonde. And then we'll try and summarize.
Thank you very much, Chair. I wasn't going to say anything, but you know how the adage goes, speak or forever hold your peace, and I don't want to hold my peace, so let me speak. Chair, I was going to support Honorable Sukas and Honorable Maneli. I do agree that if Advocate Madonsela now finds herself motherless or an orphan, as you indicated, then we should definitely then do away with her, with having her as a witness. I agree that at the time the Public Protector's team had indicated that she would add value to the inquiry. And Chair, I would like to remind us as a committee that, the purpose of this inquiry is to gather as many, facts as we can in order to be able to, make a recommendation to the National Assembly. So I tend to agree that if we are finding ourselves in this situation for the sake of time and the sake of expediency, that we should actually do away with her as having her as a witness, and then dispense with Mr. Mataboge because, he's almost halfway done. And then we get the Public Protector, because I think she is the subject matter of this inquiry. And we really need to hear from her. And I'm sure she is, also looking forward to, giving evidence to this committee and having her side of the story, related and ventilated. So, Chair, for the sake of time, which is not on our side, I would agree with Honorable Sukas and Maneli that we please proceed and move on, because I find that we are constantly getting bogged down with issues that we really which really do not constitute the subject matter of this inquiry, and it's one issue after another, and they're getting really exhausted, and we're moving away from the bigger picture here, which is trying to to do the work that we have to do as the inquiry. Yeah, I think that's it from my end. Thank you, Chair.
Thank you, Honorable Dlagude. Honorable Gondwe. Honorable Dlagude, I see your hand, and then Honorable Olomisa.
Thank you very much, Honorable Chairperson. Listening to my colleagues and the majority view, I want to retract my statement. Thank you.
Okay, thank you, Honorable Dlagude. Honorable Olomisa.
Thank you, Chairperson, colleagues, and everybody else who is on the platform. And I was raising my hand to support the proposal by the Chief Whip of the majority, the Deputy Chief Whip of the majority, Mahmoud Dlagude, but I hear now that she is withdrawing. Notwithstanding that withdrawal by her, I fully agree with her earlier position that we need to allow the committee to invite the Public Protector, the former Public Protector, Prof. Thuli Madonsela, and then the evidence leaders, as well as the legal representative of the Public Protector, would still be free to pose any questions. I don't know what is the problem here. Unfortunately, there is a legitimate expectation on the part of the public, since the name of Prof. Thuli Madonsela and the controversies around her statements and whether she will participate. I think it would be fair for this process that the committee should invite her and clarify whatever we want to clarify. So for us to say no, we don't want to be associated with that kind of drama. Thank you.
Chair.
Thank you, Honorable Olomisa. I think I've listened to all the members. It's my duty to summarize what I think I'm hearing them saying. I don't know what that hand is.
It's a small hand.
Advocate Mbofu, because
It's a finger.
You're not one of the members, so I need to summarize what they are saying.
Okay.
So
fine.
if you want to come in,
Okay.
please come in.
I do.
Before I do that.
Yes, please, Chair. Hopefully before you summarize, yeah. No, Chair. Really, you know, I don't know whether it's deliberate or not that people just want to torture us emotionally today. Chairperson, I've said that, you know, the public protector is a human being, and she is owed, the least that you owe her, all of you, is fairness and consideration, as much as you would want to if you were facing impeachment, dismissal from office, whatever, you know, or if it was one of your relatives or someone you know. That's all. We don't ask for anything more than that. But this kind of cruelty and vitriol is just unpalatable. The public protector has never said that she does not seek the evidence of Advocate Madonsela. In fact, she has said the opposite. I read it out to you this morning. When Advocate Madonsela thought her evidence was only confined to CX, we pointed out to her, for which she was grateful, that no, the committee has raised two issues, CX and Frede. And I agree with Mr. Ngola, much as I don't like to agree with him often. But, but he's 100% correct. Those were the two issues that were identified by the committee. Advocate Madonsela, because we wanted to consult with her, not because we did not want her. We said, please, we want to consult with you. She says to us, what are other extra issues that we need to put on top of the one or two that the committee? Then we respond by giving a list of the 8 other issues, including the issue that Honorable Ngola, again, I don't know why I'm agreeing so much with him today. This is what Honorable Ngola said to Mr. Siabi. That's one of the issues we listed there. When the old man was sitting there, 8 years old, crying tears, and explaining what regard is that Advocate Madonsela is due to come and appear before this committee. We surely will ask that question on your behalf. We hope that you'll be watching for you to get other answers in respect of that particular specific matter that you raise in paragraph 22. Says Honorable Ngola of this committee to Mr. Siabi. We raise that with Advocate Madonsela to say, apart from Frede and CX, there are issues such as these where people have accused you of the most horrific things and the most horrific behavior. You need to have your chance to clarify. Maybe she might say, I've never even heard of Mr. Siabi, or it was not me, or whatever it is. So we raise those issues. But now people are saying, by saying that, we mean we don't want to speak to Advocate Madonsela. When we were the ones who brought those witnesses here, Mr. Nyatela went on the whole day about what he perceived to be emotional torture at the hands of Advocate Madonsela for delaying his matter for 11 years or whatever he alleged. And it's only fair that Advocate Madonsela should be given an opportunity to deal with those issues, even if it's just to deny them. And so anybody who really is so heartless to think that by raising all those issues, all it means is that, oh well, then more than that, we begged Advocate Madonsela last week only to say, please, we want to consult with you so that we can raise those issues. She elected, as she's entitled to, as any South African, that she would rather talk to the evidence leaders or her own lawyers. That's fine. But that does not take away the rights of the public protector to raise these issues. So, Chair, to assist you, maybe this is what should happen. It's either we Advocate Madonsela is asked to consult with us so that we raise these issues and then we present a statement. If she is averse to that, then she can consult with the evidence leaders and they can prepare a statement on behalf of the committee or whatever. And the rules are clear as to what should happen in either one of those. We don't care whether we're going to lead the evidence. But for anybody not to understand, we can't lead somebody on a statement that's prepared by somebody else. It doesn't happen. If we take her statement, then obviously we will lead her. Leading evidence means examination in chief. That means you already know what that witness is going to say because you are the one who consulted with that witness. You are the one who prepared their statement. And that is why when Mr. Mataboge, also exercising his rights, chose not to make a statement, he was then told, fine, there's nothing we can do. We can't put a gun on his head to make a statement. And he was called here. He was led by the evidence leaders. We are now at a point where we are about to cross-examine him. It's a very, very simple issue, which is catered for by the rules. But this notion of saying that, let's throw the baby with the bathwater, or as the cruel King Solomon said, let's cut the baby into half so that we can see who the real mother is. It's just, unbecoming of a body like this.
Thank you, Advocate
Sorry,
Mpofu.
Chair, just 1 second. Let me just check my notes so that I don't bother you again. So the notion that she's no longer needed must be rejected. It's a question of, and I had suggested that we go to the back room and talk to the chair and engage and so on and find the most practical way of doing this.
Okay. I'm still on...
Chair, I'm sorry.
Please wrap up.
I know, Chair. Yeah. No, okay. No, it's fine. I think, it's all right. I don't even think I need to address the issue of what Honorable Tlakuta is saying, of thinking that we should, if there are 3 meetings, you prepare for all 3 meetings. When the committee cancelled the meeting yesterday, which we had asked for, so I don't know if you prepare for meetings that have been cancelled. We asked for the witness to be brought today, and you decided not to. So how would we prepare for that? Now, Chair, sorry, there is just a small, yes. My constructive proposal, Chair, is the following: that we, after you've summarized the position, we leave this issue because it should not be resolved like this in the public domain. We leave it as to how and when Professor Madonsela should be brought to assist the process, the committee, by whoever will lead her. And then, because this is now 25-1, Chair, we would request, and I would like you to incorporate that maybe in your summary, we would request that if you are still interested in not wasting the time and maybe having Mr. Mataboge, that we have that in the morning so that we have an opportunity to go and prepare, because we had come here having prepared for something completely different. So that's our constructive proposal on both issues, Chair.
Thank you. Mr. Ibrahim, I want to summarize the members' discussion. Please switch off your mic, Advocate Bauer. Mr. Ibrahim?
Chair, I just wanted to place something on the record for clarity. Mr. Mataboge is a distinguishable witness. He was not requested by the Public Protector. He was not part of the list of people that they wished to summons. The committee, having regard to Ms. Bianca Mvuyana's reasons for not wanting to come to the committee voluntarily, then made a decision to call her, and that is how it then followed that the evidence leaders led Mr. Mataboge. This is distinguishable in that the Public Protector has requested that Professor Madonsela appear because they have a list of questions which they wish to put to her. So if I can just please have that on the record. Thank you.
Thank you, Ms. Ibrahim. Advocate Bauer?
Chair,
Advocate Bauer?
sorry, maybe before you come in.
Advocate Bauer?
Oh, okay, sorry, Chair. But please then recognize me. I want to correct
Chair,
that.
I do feel it important to remind the committee and maybe to coin a phrase that Advocate Mpofu has used several times in the proceedings. This is not a motion to examine the behavior of Advocate Madonsela in any instance. So if any way she may have treated anybody, let's assume the worst case scenario that what was told to this committee is true. For purposes of the work of this committee, the question to be raised is so what?
Thank you, Advocate Bauer.
I'm happy with that.
Let me now summarize for the committee. I will start with the issue of Mr. Mataboge. Mr. Mataboge was scheduled for this committee, evidence leaders led, and at the point of the Public Protector legal team having to take over, they invoked the directives, which was accepted. And at the time, we would have planned for an allocated set of time for Mr. Mataboge. We received the request that the Public Protector legal team would like to, because he's scheduled for Friday, for us to complete with him. In the to and fro, they would have requested that he come in today and tomorrow, basically requesting to add another day on the programs. So that has to be acceded to first. It's not just automatic that would do that. Well, if it's 2 days of Madonsela, it belongs to Madonsela, not Mr. Mataboge. And so I had made a ruling earlier that says, with Mr. Mataboge agreeing, with the Public Protector team being able to do that, we want to spend the rest of this afternoon and as well as tomorrow with Mr. Mataboge. I get, even though Advocate Mpofu said he will still speak to his team, that there's no readiness for today for Mr. Mataboge. Which therefore means we're left with tomorrow with Mr. Mataboge. I would have loved that we would have given the Public Protector legal team tomorrow as well as the rest of the time of today. But as indicated, they do not think that they will be ready to interact with Mr. Mataboge today. And if I want to accede that we will continue with Mr. Mataboge tomorrow, and Mr. Mataboge will end tomorrow, whatever time we end. That's the time for Mr. Mataboge.
Yeah, Mr. Mataboge has a 5 o'clock restriction for personal.
Okay, I know that's 5 o'clock, but at least that's we use the same, so the allocated time is fine. So, which is what would have helped that you spend the rest of the hours we have today as well as tomorrow. So that's on Mr. Mataboge. And I'm saying Advocate Mpofu did indicate that he was going to speak to his team. But if that does not materialize, that we conclude Mr. Mataboge tomorrow, Thursday being the 2nd of March. On the next 2 points, in listening to the members on their discussion, I think firstly, the first issue that must be concluded is the cleaned up statement must be finalized, because there were corrections made to the statement to attend to all of the issues that can be tricky points, so that there's no questions around that statement, even though I agree it's cosmetic changes. So I'm sure by the time we close this meeting that could be done, if it's not done now. With that statement cleaned up and done with all of those corrections and cosmetics, having listened to members, I had put the question to the Public Protector legal team. They have given me a clear response. I cannot doubt that. And on the basis of that, colleagues, to bring Honorable Ngola's points and Honorable Olomisa, as well as the rest of the other 5 members who had contributed to this issue. This is the ruling I make on the matter of Advocate Madonsela, who's been with us this morning, is still with us, and we appreciate that. That cleaned up statement would Honorable Ngola assist in your neutral ground that you have indicated, because we adopt that as a committee, that she responded to the 2 issues we asked her to respond in a written statement, Friede and CX. The statement speak to those issues as required, as decided by the committee, and that we take that as a committee as a written evidence, which is on record to this committee, and therefore it helps us therefore as a committee to do away with the proposed oral evidence of Monday and Tuesday, because we have that on record, so that we don't get into. I've addressed that enough, and I think that the members have accepted that the committee must adopt the witness, Advocate Thuli Madonsela, and therefore that adoption with the cleaned up statement means we have on record her response to the issues that were required, and therefore we would not need to go any further with an oral evidence when she would have responded to those gray areas that we wanted her to respond to. So in that regard, that's how I want to conclude the matter on Advocate Madonsela before I thank her. Is there anybody with a grief from members on that? Maybe I'll start with Honorable Olomisa. Honorable Olomisa.
I raise my hand to completely disagree with your approach, because if one of the members of the committee during the discussion wants to ask questions, are we going to write another question, put another question in writing to her to clarify? Why are you hiding her not to come and answer questions verbally? And just ruled out of the blue.
Thank you, Honorable Olomisa. Your objection is noted. Any other member? None. Thank you. And that is now going to be the decision of the committee, noting the objection of Honorable Holomisa. I want to move now from this point. Perhaps you raising your hand, Advocate Mpofu, and then I'll go to Ms. Ibrahim.
Right. Now, Chair, I just want to say this, that I don't know why these members of this committee are complicating the work of this committee and making it more difficult for us to proceed with the inquiry, because the things that you are doing in the last 48 hours really are just, I don't know whether it's a plan to try and sabotage the committee, because you know that it's not going to end well, this approach of just bulldozing. Firstly, I just want to make a factual correction. Ms. Ibrahim is wrong, because we gave you a list of witnesses, and it was like this. Okay, I won't read out the people who have not appeared here. It says, latest, after you insisted, Chair, that we give you a list. Latest list of witnesses, confidential and not for external dissemination, as at 8 November 2022. Number 1 was number 1. Number 2 was Honorable Zulu Sakoni. Number 3 was Mr. Rodney Matabuche. Number 4 was Bianca Mviane. Number 4 was number 4. Number 5 was number 5. Number 6 was Advocate Mkhwebane. Then Lamola, Freddy Nyatela, and so on. Then those to be approached, Godan, Madonsela, Mazoni. And then still being traced, Mr. Peter Siabi. That was the list that we sent to you and the committee per your request. So that distinction between Mr. Matabuche and Ms. Mviane is not, Mr. Madonsela, Ms. Madonsela, Advocate Madonsela, Professor, is not true. So it's all very well to do things here for convenience, but they're not going to withstand proper scrutiny when the crunch comes, because we just want to run roughshod. When the facts are now put, and that's why I brought these letters to read them to you, so that you make your decisions on an informed basis, not an emotional or vindictive basis. So that's the issue. So the comparison I was making with Mr. Matabuche is completely valid. Secondly, Chair, you can't, on the basis of this statement or affidavit, well, I don't even want to call it an affidavit, which does not even address the issues that Honorable Ngola is talking about whether there was a change of or a manipulation of dates or whatever by Advocate Mkhwebane. Even forget about all the other issues, just on Friday and CX. It doesn't deal with those issues at all. It doesn't deal with the issues raised by Mr. Samuel about what Advocate Madonsela said to him, about when the file was being transferred to the Free State. A whole host of issues. I don't want to bore you with a list, but it doesn't even scratch the surface, that statement, on the issues, just on CX and Friday, forget anything else. So for you to come and say those issues are addressed in the statement, it's just not true. You might as well throw it into the dustbin, because it doesn't deal with those issues at all. Now, let alone the issues that Honorable Ngola said would be dealt with the statement. But I'm happy to hear what the evidence leaders are saying about that issue. And I want, even if she comes, I won't ask any questions to do with that, because according to them, we must then just accept the evidence of Mr. Nyathela and Mr. Siabi, because even if it is so what? Great. So that we will deal with in the implications of that concession will be dealt with when we do the argument. But for our part, we require the evidence of this witness. The evidence of this witness is clearly relevant. And if there's now going to be a somersault on calling her, then it will be a matter that will have to be resolved in another forum, because now we're just being bullied into a situation or depriving us and the committee, or well, at least the public protector. The committee, if it doesn't want to know the truth, that's fine. But the public protector is denied her right to call a witness and question her about issues that are clearly relevant to this committee. So, Chair, as far as the other matter of Mr. Matabucha is concerned, this is, at least my team's view is this, that if the, I had forgotten about his 5 o'clock restriction, because I had thought then if we were going to start with him, then we would just go on for as long as possible, so that, or either today or tomorrow. So what we would propose, Chair, on him is that if we can even start, at least the suggestion from my team, that we can start with him at 3 o'clock, so that we do the one section, at least, of the 4 reports, and then hopefully maybe we start early tomorrow at 9, and see how far we go with the other 3 sections, given his 5 o'clock restriction. But on the I really wish you had just adopted our proposal, which we repeated many times, which was that the issue of Advocate Madonsela should be left to a discussion between yourself and the evidence leaders, and try and resolve it. I appeal for you to do that, because I think the alternative is not going to be very pleasant. So we need to get over with this, accommodate and be fair to both the committee members and the public, and Advocate Mkhwebane, and of course Advocate Madonsela herself, and try and find a solution that is not characterized by bully boy tactics, and one that is constructive, that is going to take us forward and accommodate the exigencies, so that we take into account the interests of fairness. And Advocate, or rather Dr. Gondwe, I think, has made a Freudian slip. She says we must do this for the sake of expediency. Well, if we are going to do things for the sake of expediency, then I think we all know where that will lead. I think she wanted to say expedition, but expediency is not going to get us far. Thank you.
Thank you, Albert Mpofu. Mr. Brian.
Chair, just 2 quick things. The one is that the PP's legal team made it clear to the evidence leaders in a meeting in which I was present that they had no intention of calling Mr. Matabucha any longer. So notwithstanding that Mr. Matabucha was still on the witness list as submitted, the intention was clearly conveyed in much the same way that the evidence leaders over time have also conveyed their intention not to call certain persons who were on the original witness list. But anyway, be that as it may, Chair, the real issue that I want to attend to is the one regarding the statement by Professor Madonsela. The statement dated 28th of February already contains all of the changes that were made by hand now in an electronic format, so there is nothing further to be done. So I just wanted to clarify that we don't now need to go back to ask for anything over and above what we've already received. Thank you.
Thank you. Quickly on the issue of Mr. Mataboge, I was hoping that you would request 2, but you're requesting 3. That's fine. I will accede to that. And then we can also ask members to be flexible and we'll start at 9 tomorrow, if that's okay with the members. So let me repeat it again. The request, which I think that is fair, was only raising an hour in it, but I won't go to war for that. The request was that to start at 3 this afternoon. We have extra 2 hours with Mr. Mataboge.
Chair, I'm sorry to interrupt you. I'm even prepared to compromise. We can make it 2:30. I needed 2 hours just to
That's
prepare,
fine.
to go and fetch my notes, and because I've left all those files in the
Okay.
hotel and all that. Yeah.
That's in order.
So, yeah.
So we'll start 2:30 with Mr. Mataboge, and we'll start at 9 tomorrow. Is that in order, members? An earlier hour than 10? Honorable Jakude?
Thank you very much, Chairperson. We fully agree. Thanks.
Okay, thank you. So that's it, members. Now it's about 1. Maybe let me take this opportunity to address Advocate Madonsela. If you can maybe switch on your camera.
I'm so sorry. Sorry, Prof. Yeah.
Okay, just pause, Advocate.
Yes. No, Chair, I just wanted to say that, sorry, I forgot to say that. Okay, well, it won't change the 2:30 thing. Maybe we'll send it for you overnight or for tomorrow. That if you go ahead with what it looks like you want to go ahead with now, then one of 2 things is going to happen, which is either to take that issue to court or to make a fresh application for you to summon the witness, and maybe that's what we need to do to exhaust, because we have to exhaust our remedies. We can't just, but that's something we're going to do, in which case you'll probably have even a much longer delay in your hands. But that's, I just wanted to say so that you don't overpromise anything to the witness. I think we're going to see her either soon or later. Thanks.
Well, I don't know about that anticipation. Firstly, you don't know what I was going to say with the witness.
No,
Let's just
no,
put that
I'm-
very
I'm
clear.
basing it on what you already
no,
said.
I didn't recognize you.
Oh, sorry.
Thank you.
I was not addressing what you are going to say. It's what you said already. Thank
No.
you, Chair.
Thank you. Advocate Thulisile Nomkhosi, I hope I'm doing it right, because there was a Nomkhoso thing and so on. Nomkhosi Madonsela. I want to, as a chair, firstly, profusely apologize that we had you here since 10 o'clock as scheduled and directed by the committee. It is now 1 o'clock. You've been patiently sitting there and waiting for the opportunity for you to present to this committee your testimony. We have not even taken an oath with you, because we're going to do that when we're ready to proceed with you. So I want to take the opportunity to firstly apologize that we had kept you for so long, and you you are interacting with a discussion that you are not part of, and the discussion is about you. Must have been very difficult sitting there. So one appreciate also that self-control and discipline. You would have heard and listened to us engage in this discussion, and the members articulating their positions, and I just summarize that. So I'm inviting you in order to indicate to you that we would not be proceeding with you as originally planned, that we had a date with you today and tomorrow. It does look like a date ayambi kahle. So that's a point I want to make. But also, having listened to the summary about what I've just concluded on in the statement, it's clear we're not going to proceed with you today and tomorrow. And we've made that conclusion. If there will be a need for us to speak to you again, we will indicate that. But as of today, we want to thank you for availing yourself before today in preparing for these 2 days and being with us for this half a day. And again, I apologize for essentially wasting your time in that way that you would have utilized somewhere else. Thank you very much. Anything you want to say?
No, just to say thank you, Honorable Dante and Chair, and to the members, and that should there be anything relevant that I can assist with, I'm always willing to assist.
Thank you very much. I think that helps a lot going forward. We will interact with you if there's anything relevant or anything new. Thank you, Sis Nomkos.
Thank you, sir.
Thank you. You are excused. Thank you, honorable members. We'll now take a break for an extended lunch, and we'll be back if you still are agreeing for 2:30. So we'll be back between 2:30 and 3. Let me put it in that way.
That's better, Chair. Yeah.
So that
When
when you are not here at 2:30, we don't look at you and say
Please.
you. Okay.
Yeah, but it's not far.
No
Just
problem.
have to fetch my files.
We understand.
Yeah, thank you.
Thank you. Meeting adjourned for now until then.
Recording stopped.
short notice. Yesterday we had wanted to call you today anyway so that we could speed up things. But we will go for as long as you are willing to let us go today. If there's a need to go slightly over 5 o'clock, will you be able to do so?
Yes, I think it's 5, 6 are available.
The latest. Okay, thanks. We'll try.
Yes.
Thank you very much. Now, what we need to do, you have been called effectively, according to the evidence leaders at least, to deal with 4 separate reports. Those that were raised with you at the beginning of your evidence. And those are the CR17 Busasa report and judgments. And then there's the so-called rogue unit judgment and report. And to that extent, your evidence coincides with that of Ms. Mvuyana. And then there was an issue of Friede 2. And then, of course, the Pillay pension matter. Can you confirm that you were involved in all those matters to whatever extent?
Yes, sir. I was involved as the chief investigator that supervised the investigators who dealt with the 3 matters, that is the Having Pillay pension matter, the SARS so-called rogue unit, and the Friede 2 report. However, Busasa was the lead investigator because it's an MER.
Oh, I see. So, yes. In the other 3, you had you were supervising the actual investigators or senior investigators, and in Busasa, you were yourself the lead investigator.
Correct.
Perfect. Thank you, sir. I was not aware of that distinction. Right. Well, in that case, then I'm going to start with dealing with the Busasa CR17 matter, but in that sequence, if you don't mind, and we'll see how far we go until such time that we have to go, or if you cannot go any longer, and so on. And then we will deal with the other 3. But before I do any of that, we need, I always say to the legally trained witnesses, as you know, context is everything in law, correct?
Correct.
Yes, so we always try to paint the context of your evidence so that even the members know upfront where we're going and who is this person in front of us. Unfortunately, this time, the evidence leaders have done most of that work of situating where you fit in the big picture. But just for the sake of, without repetition, and I will ask you questions of that nature to save time in a leading fashion, either because the material is not controversial or because in any event, some of it might have already come through from Ms. Mvuyana and it was not disputed. You follow that?
I do, I do.
Thank you very much, sir. All right. Now, it's already been registered here that in terms of the what I call the pecking order, in a particular investigation, ideally, and we know that this doesn't happen with each and every investigation, but ideally you would have the investigator, senior investigator, chief investigator, that is somebody like you, leading the actual investigation team, correct?
That is correct.
And then above you would then be the executive manager, who reports to the COO or has a dotted line to the COO, and then the public protector, correct?
That is correct.
Right. Now, we also established with Ms. Mkhwebane that the person who is, with the exception of the Busasa exception that you just told us, the person who would be, quote unquote, on the ground in respect of such an investigation would be the investigator himself or herself, correct?
That is correct.
Yes, and obviously then they would report to you and check with you as and when your intervention is necessary. And you said something quite important. I think you were asked by Advocate Bawa about the reporting line. Can you just confirm that when it comes to drafts, the investigator can sometimes interact directly even with the PP or the EM without necessarily coming through you? But when it comes to a final, let's say Section 7.9 or a final report, then it must go through all the stages that we have already described until it is signed by the PP. Is that correct?
In fact, it works both ways in a way, in that when the investigator starts, it starts with submission of investigation plans, document request letters, all of which have to be submitted through a memo that is prepared by the investigator, and then that goes to the CI, which is me, and the executive manager to CO up to the PP. So that process, that flow of investigation applies both even for the subpoenas, for the 7.9s and so on. It depends, as I was saying, yes. It depends on the nature of the complaint.
Yes. Thank you. Yes. Sorry, I forgot to mention. Yeah. Even the subpoenas, because they also, as far as the legislation is concerned, they are issued by the public protector, but as you say, they then would travel that whole journey. The public protector herself might not know who must be subpoenaed at whatever time, but once you've made those decisions, then it travels until she has to sign the subpoena or a Section 7.9 or final report, correct?
Correct.
Good. Right. And you also made the statement, you said an investigating diary or investigation diary is the life cycle of the investigation. And I suppose that in that life cycle, we can also include the investigation plan as, if you like, the lifeblood of the investigation or the blueprint. And Ms. Mkhwebane explained to us what an investigation plan is. But would you agree with that summary?
Yes, that is correct. I agree with it.
Right. And for the purposes of this committee, would you confirm the evidence of Ms. Mkhwebane that in actual fact, the deadlines or the original deadlines, because deadlines might change from time to time, if you have what in this committee is called a living document. But the original living document, if you like, is the investigation plan, which is drafted by the investigator himself or herself. In other words, the first deadlines are self-imposed in that document, correct?
It is correct.
And then, of course, we now know, even those of us who have never been to the Office of the Public Protector, we now know that there are all sorts of meetings, dashboard, full bench, task team, what have you. And in all those meetings, then the deadlines might be adjusted. If I don't meet a particular deadline, I might get some serious talking to, but if my explanations are correct, then the deadlines get changed. Even so now the deadlines become negotiated rather than self-imposed, correct?
That is correct.
Yes. Good. Can you just very briefly, I know that you are one of the most experienced investigators, having started working in this sector even before 1994, when your particular office was located in the homeland, or before 1994. Can you just tell us, without getting into much detail, the various stages which you have played in this sector up to where you are now as chief investigator?
When I started in the ombudsman, I was a junior investigator. Then I became an investigator, I think, around the 90s. In 1993, I became a regional manager in Mkhwebane, where I had to move from Mabati to Mkhwebane to manage a regional office, which I was a manager for until 2012, when the office was closed, and I was relocated along with the staff to head office in 2012, I think November, where I became a senior investigator under the GGI, which is Governance and Integrity. And I was a senior investigator from 2012 up until 2018. I think June, when I was appointed the chief investigator, the position that I am still holding today. Thank you.
Good. Thank you very much. Yeah. And to cut a long story short, you have therefore been there throughout all the public protectors, from the first one, Advocate Selby Bakwa, to Advocate Mushwana, Advocate Madonsela, and now Advocate Mkhwebane, correct?
Correct.
Thanks. Good. Well, I won't even ask you. You probably don't even know how many investigations or reports you have been involved in. But we can accept that it's a lot in that period, correct?
Quite a lot, yes.
Yes. And that wealth of experience must have contributed to you being identified as what you've called the lead investigator in such a big and serious matter as CR17 Busasa, correct?
I believe so.
Yeah, thank you. Okay, you don't have to be modest, Mr. Watabuch.
No, the reason is that I do so is because that had been happening to me even before getting Mkhwebane.
Yes, okay. That you got the what sometimes is called the graveyard shift, that you would get some of the heavy lifting.
Yes.
No, fair enough. Thank you. Right. Okay. We will come to that particular report just now. Now. The other thing that you said, which for me really characterizes the evidence that some of the issues I'm going to deal with you, if it was a court case and not an inquiry, after that answer, I would have just said, well, that's it, I have no further questions. But unfortunately, we're in an inquiry, so we have to inquire into the factual issues. But you said last week to this committee and I'm quoting you verbatim, we may fall short, but we do our best. We endeavor to be fair, and we do our best. We work without fear, favor, or prejudice, notwithstanding some of the comebacks. You remember that?
I remember that exactly.
All right. Thank you. So your evidence, both through this questioning and probably when we summarize and argue at the end of the case, I will be put under that that theme. Now, I put to Ms. Mkhwebane yesterday a proposition that if all the horrible things that the public protector is being accused of in relation to these reports, let's say these 4 that concern you, namely that she was deliberately dishonest, biased, out to get Mr. Ramaphosa or out to get Mr. Gordhan, and out to whitewash Mr. Mahashula and Mr. Zwane, no matter what they had done. Which is the gist of those charges, if that was indeed the case, she could not have carried that out without, to use the word loosely, recruiting somebody like you, Ms. Mkhwebane, into that conspiracy, if it was going to be successful. Would you agree with that?
Yes, I would definitely.
Yes. And for the record, were you ever part of any scheme, conspiracy, vendetta to target a particular focus person of an investigation, such as the ones that I've mentioned, or were you ever aware of such an intention being harbored by the public protector?
No, I wouldn't have been at all. Yes. Especially because when, if I may just elaborate, when
Yes.
we dealt with the matters at the beginning, we would consult with the members of Parliament who have brought these complaints as required in terms of us confirming or looking at the issues. And I would be part of those meetings, or the investigation would be part of those meetings. If there were any undertones or any such, I would have known or picked them up for sure.
Yeah.
But we were questioning them on why they think were the appropriate institution can investigate what they were alleging against a particular member of the executive as well.
Thank you. That's quite crucial. Yes, you actually made that very clear. Excuse me, Chair. And I think Ms. Mkhwebane also emphasized that point. When you testified, you said the first thing we do is to consult with the complainant, which is what you are saying now. And I think as a lawyer, you and I know that you cannot pursue a case, whether it's a criminal case, whether it's a disciplinary hearing, whether it's an impeachment process, without hearing from the complainant, correct?
Correct.
And I think that's what we are telling the committee now, that in the case of the Public Protector's Office, a similar process is followed. In other words, even before the Public Protector could execute her quote-unquote conspiracy, she would have to contend with the fact that you, and not her, have to do the screening of the complaint with the complainant, and only if you, not her, is satisfied that this complaint even merits being taken any further, then the show gets on the road. Is that a fair summary?
It's a fair summary, yes.
Yes. So I think what you are saying is even taking it further than what Ms. Mkhwebane told the committee, in that you are saying that not only would you have to be a member, quote unquote, of that conspiracy, but you would have to be a very important one, because without you, whatever conspiracy the public protector might be harboring could not be carried out, because you would have said that this is a nonsensical thing. There's nothing here. There's not even a prima facie sign. It's clearly just a witch hunt, and we should not waste the time of the taxpayer on the money of the taxpayer with it. What I'm saying is that you, obviously, if you are a member of the conspiracy, then you wouldn't say that. You would say, no, let's go ahead, because this is Mr. Ramaphosa, the one we've been looking for, or Mr. Kodan. Understand that?
Yes, correct. But EMEA as an executive ethics code complaint, we don't have an option not to investigate.
Good. Good. Yes. Yeah. No. Okay. Therefore, no. Fair enough. So that question that I just asked you now would apply, obviously, to the non-EMEA complaints, which, such as the Pillay complaint. Oh no. The Pillay complaint against him, but the one against Godan would have been EMEA. What I'm saying is that the discretion for you to proceed or not to proceed applies to the non-EMEA complaints, correct?
Yes, correct. But those ones that we call SEM, which are special attention matters, would be complex and crucial ones that then we discuss and we hold meetings in the presence of the Public Protector,
Yes.
despite them not being EMEA.
Yes, no, okay, fair enough. Yes, I think one of the earlier witnesses told us about the so-called SAM. So, for the purposes of Honorable Ngola, the SAM are called, rather, what's the full special what?
Special attention seeking matters.
Okay, special attention matters. Okay, now otherwise known as SAM, Mr. Ngola. Okay, thank you. So once again, thank you for that qualification. So both the EMEA and SAM matters would, firstly, with the EMEA matters, you have no option because the legislation says you must investigate. But with the SAM matters, that decision would be taken in conjunction with the Public Protector, correct?
Correct, yes.
Thank you. All right. Now, I then just want to take you were told last week, so I want to spend much time on this, that your evidence is really relevant for charges 11.3 and 11.4. To save time, I won't read them back to you, because I think Advocate Bauer read them to you, or I read them to Ms. Mkhwebane. But in a nutshell, those charges relate to deliberately seeking to avoid making findings against certain people, and deliberately or and deliberately, avoiding to make such findings against others. You remember that? Or do you want me to read
Yes, I remember. I even remember my response.
Yes. Which, please, can you repeat?
Which was in the negative.
Yes, thank you very much. Yeah. All right. So, as I did with Ms. Mviana, I have to say this also for the benefit of the members and the members of the public. My questions to you are not necessarily aimed at establishing, for example, that the so-called retirement of Mr. Pillay, which was like a 1-minute special where he quote-unquote retired at 12 o'clock and then in 1 minute past 12 he was re-employed. It's not necessarily to show that that was a sham, because I think that should be obvious to anybody. The purpose of your evidence here is to determine whether or not in the process leading up to that so-called retirement, any legal prescripts had been breached. You understand that distinction, correct?
Yes, I do. Yes, I do.
And do you agree with that is the emphasis? In other words, you are not here to tell us whether it was a good thing or a bad thing for Mr. Pillay to retire, or to retire to fund the education of his children or whatever he claimed. You are just here to check whether, as far as that retirement is concerned, and even assuming that it was warranted, it breached any law, the PFMA, the Constitution, the Pensions Act, the Public Service Act, and those kinds of prescript, correct?
Correct.
Right, and that goes for all the other investigations. Busasa, it's not for you to tell us whether it was a good thing or a bad thing for the funders of the CR17 campaign to give R1 billion or whatever amount for him to become the president of the country and the president of the ANC. Your focus is only whether in receiving those funds, the Executive Ethics Act was breached, or any other obligation to declare and that kind of thing. Correct?
That is correct, All
right. All right. Just so that those people who are inclined to send you nasty WhatsApps, they must just know that your job is actually much more boring than trying to accuse anybody of anything. Yours is simply to look at whether the prescripts of our republic have been followed. Correct?
That is correct.
Right. And in doing so, it doesn't matter if it's somebody that you like or dislike, whether you like me or the chairperson or anyone else. Once a complaint has been raised, you just have to disabuse yourself of that liking or disliking and simply look at whether me or the chairperson followed the rules that bind upon us, and the answer is either yes or no. Correct?
That is correct.
Right. All right. Then there's also, there's some interference. I don't know whether it's.
Yeah, we are attending to it with Mr. Ngoma.
Thank you, Chair. Right. Now, I just want to go to the issue of jurisdiction, both broadly speaking, but also in relation, also because it arose in the Busasa matter, which I'm going to start with. It is correct, is it not, that apart from speaking to the complainant, one of the first things to be done, obviously, in any matter, is to determine jurisdiction, correct?
Yes, and we do so by checking the applicable legislation.
Yes, because again, if you come to the examples I was making, let's say the chairperson has transgressed the rules, which of course we know he would never do, but even if he has transgressed them in multiple and daily fashion, very unlikely, then yours would be, it wouldn't matter if he has transgressed them 1,000 times, if indeed you find that you don't have jurisdiction. It's a matter that falls in the hands of the police or someone else, correct?
It is correct.
Okay, and as these examples are getting more gruesome, I will use someone else, otherwise I'm going to be muted. So, the point that I'm simply making is, yes, the complainant, the screening, or what I think Ms. Mviana called the preliminary investigation, involves typically, obviously not in every case, involves speaking to the complainant, but also ensuring that the public protector has jurisdiction in terms of the legislation, as you correctly say. Correct?
That is correct.
And the powers of the public protector are located in Section 6 of the Public Protectors Act. That's really what you are doing. You are just checking against Section 6, and where Section 6(1)(a) is my favorite one, the one that gives the wide ambit of your powers, starting from discourtesy, or, to...
Capricious.
Yes.
Yes.
And discourteous and capricious conduct, right up to the hardcore stuff, like corruption and all that, correct?
That is correct.
Yes. So I was describing it to one judge like that, to say that actually the powers are so wide that even if a civil servant just doesn't greet me, I can go and report them to the public protector for being discourteous, correct? Well, I'm sure you haven't had cases like that, but just to make a point, I'm saying that it moves from the mundane to the serious, correct?
That is correct.
Right. Right. And in the case of the Busasa matter, the issue again was a serious matter of, let's say, ranging from the failure to declare a gift to possibly criminal conduct in the form of money laundering, which is some serious business, correct?
That is correct, as the complainant had put it to us.
Yes, the complainant in that particular case, Mr. Busisiwe Mkhwebane, the then leader of the DA, had, at least in his specific complaint, alluded to the criminal conduct of money laundering, correct?
That is correct.
Yes. So, like the Pala matter, which I know you are not involved in, the most serious allegations also involved the breach of PRECA and money laundering statutes of South Africa. Let's not necessarily get technical, correct?
Correct, yeah.
Thanks. All right. And either you know this or you don't, but those matters, if proven, would have, in the case of a president of the country in particular, then amounted to, let's say, to be fair, possible impeachable conduct. In other words, if a president of a country was involved in criminality, at least even a first-year student would tell you that that may, and I'm being generous, invoke a further breaches of the Constitution, such as Section 89 of the Constitution, correct?
Correct, yes.
Yes. So the matters were serious not only because of the seriousness of the offenses, but also because of the highness of the office involved, correct?
That is correct, yes.
Right. Thank you. And it is in that context then that I was giving you that compliment, that to be entrusted with such an investigation, I cannot think of a more serious investigation than the Busasa one, other than maybe the Pala Pala one. So it means that you were one of the people who have demonstrated capability and experience in this area, correct?
Yes, but if you were to remember, I try to refuse take it at some point to say I'm swamped. Can it to somebody else?
Thank you. Yes. No, I know the feeling. Yeah, and she wouldn't take no for an answer, I suppose.
That's why I was in it to the end.
Yes. Thank you. All right. Right. Okay. Now, having laid that basis, then I think it's fair then to say to the members, let's then go to the specifics. Sorry, Chair, I need to. Oh, we're going to have trouble here, Chairperson. I see that the version that I'm using is not properly paginated. Tsepo, I don't know if you'll be able to assist me to find the Busasa documents, and I'm looking specifically for the report as well as the Section 7(9) letter. Well, Tsepo and my team are looking for the correct reference, but you can confirm that the report was issued by you and the Public Protector in
July, I think 19 July.
19 July 2019, correct?
Yes.
Yes. Yes, thank you. Yes, that's correct. And thank you so much, sir. What's the front page report? What's that page number? Oh, okay. Sorry, I thought it was me, just me. Okay, there's no page number. So how do we identify it? We'll use the paragraphs, yeah. I think, does that mean it hasn't been loaded? but it's not paginated. Okay, that's fine. We'll sort that out. Chair, can we'll just use the paragraph numbers for now. Okay, but for the members to find it, I think at some stage we'll have it paginated. So, thanks. Okay, I'll just read snippets which will give a full picture. If you go to, if you can go to paragraph E under the executive summary. Yeah, sorry, go to G. Okay, the parts that I'm jumping are the well-known parts where Mr. Maimane posed a question in Parliament about members of the family benefiting, and he had a receipt or something, and the President responded to say that he had looked at his son in the eye, and so on and so on. And if it turns out that there's an illegality, he'll be the first one to take his son to the police and all that. But the part that I wanted to deal with is Mr. Maimane's complaint, which is covered in G. Where Mr. Maimane says, the report says, Mr. Maimane, in his letter attached below, further stated that it is his concern that the rest of the facts reveal that there is possibly an improper relationship existing between President Ramaphosa and his family on the one side and the company, African Global Operations on the other side. The nature of the payment passing through several intermediaries does not accord with a straightforward donation and raises the suspicion of money laundering. We've already covered that. The alleged donor is further widely reported to have received billions of rands in state tenders, often in the fashion, or rather, often in irregular fashion. And then what follows there is the actual letter of Mr. Maimane addressed to Office of the Public Protector, Advocate Busisiwe Mkhwebane. We won't go through that letter, as I say, it's also well known in the public domain. You remember that?
Yes, I do agree.
Right. And just after the letter, Tsepo, was Roman 6. Right. After the signature of Mr. Maimane, it is then indicated that another similar complaint was lodged by Mr. Floyd Shivambu, MP of the EFF, Deputy President, as well as an anonymous complaint from a whistleblower on the 28th of June 2019, who is not a member of Parliament and therefore precluded from lodging a complaint in terms of EMEA. I then decided to consolidate the two complaints into one investigation for administrative purposes. And then it spells out what Mr. Shivambu was complaining about, which is largely similar. Also, I won't bore the committee with that. But the point I wanted to highlight there is a point that was made yesterday with Ms. Mvuyane, namely that even though there was a complaint against the president, which came from a member of the public or whoever, the anonymous complainant, that one had to be discarded because it did not come from a member of Parliament, correct?
It is correct.
All right. The next, just go to the next letter, just to show it. We won't read it as well. Okay, so that's the complaint letter on the, just go further down. Yeah, that's the complaint letter on the letterhead of the Office of the Chief Whip of the EFF, signed by Mr. N.F. Shivambu, MP. So that was the second valid complaint, correct?
It is correct.
Right. And again, I won't go into the gory details of how you got there, but just to give a flavor to the members of your findings, if you go to the paragraph AA, Tsepo, that's just, it's like double A. Further down. Further down. Yeah. No, it's further down. As after F in that series, yeah. Yeah. Okay. So I'm jumping just to, as I say, just to give a flavor of what the findings were. One of your findings in Parliament, President Ramaphosa deliberately misled the National Assembly, is sustained. Correct?
That is correct.
And then let's just jump to DD, please, Tsepo. No, sorry, start with CC, because that's important. We're going to go. You remember one of the controversial issues, both in terms of the jurisdiction and the criticism that the President leveled on the Public Protector, had something to do with the question as to whether he personally benefited from these donations. You remember that?
I remember, I do.
Yeah, yes. I think that's one of the main issues. And then at CC it says, you say, and again, like with Ms. Mviana, when I say you, I know that the report is that of the Public Protector, but also I'm using you in plural because you were the, shall we call it yes, the drafter, and in this particular case also the lead investigator. Yeah. Okay.
That's correct.
Thank you. And in fact, I prefer your word is even better. You were the drafter, as Ms. Vianney explained. Actually, it's you, the investigating team, that drafts these documents. Of course, the PP has the final say, and she makes changes and all that, and she owns it. She's not trying to run away from the ownership of the report. But it is drafted by people like yourself, correct?
That is correct.
Right. Okay. Now, here you then say, President Ramaphosa, as a presidential candidate of the ANC political party, received campaign contributions which benefited him in his personal capacity. He was therefore duty-bound to declare such financial benefit accruing to him from the campaign pledges. Failure to disclose the said material benefits, including a donation from AGO, that's African Global Operations, I think, otherwise known as Busasa, correct?
Correct, yes.
And then you say that is a breach of the code of ethics, correct?
That is correct.
Yes. And then at DD, there is another important finding you made where you say, I have evidence which indicate that some of the money collected through the CR17 campaign trust account was also transferred into the Ramaphosa Trust Foundation account. So those are two of the crucial findings in respect of that finding that we referred to earlier in AA, correct?
That is correct.
Right. And then let's go to the next AA, that is under C. I'll also just read the finding, and then I won't read the rest of the narrative. There you say, the allegation that there is an improper relationship between the President, Ramaphosa, and his family on the one side, and the company African Global Operations on the other side, due to the nature of the 500,000 payment passing through several intermediaries instead of a straight donation towards the CR17 campaign, thus raising suspicion of money laundering, has merit. Now, I want to, you remember that finding?
I do agree with both.
Yes. The emphasis on that finding is just to emphasize the fact that you knew your limits. So you did not find the president guilty of money laundering, and all you could say is that it raises suspicion. After that, it would have to be the NPA or the police or whoever who has to take it forward, correct?
That is correct.
So even if you actually had a photograph of the money laundering, it would be outside of your jurisdiction to quote unquote find him guilty. You would have to refer it to the appropriate authorities, correct?
That is correct.
All right. And that is why if you go to the remedial action, let's go just further down. This is the summary. This is not the remedial action section, but just the summary thereof in your executive summary. What you recommend, having made those findings, is really quite straightforward. It's another AA. No,
if you give her the page number at the bottom of the page.
I don't have that.
Is it not at the bottom right-hand corner of your draft?
No, it isn't. But you remember the one that I just read, the DD? Yeah, there's just 2 or 3 paragraphs after that.
No, before that.
Yeah.
Yeah.
That, no, go further down. There's another AA. Okay, your numbering is, okay, good. All right, thanks. Sorry, it's not your fault. I think the numbering is, if you don't have the page numbers, yeah, it repeats itself. Thanks, Chapo. So, in that AA, it says within 30 working days of receipt of this report, the Speaker of the National Assembly, this is remedial action directed at the Speaker of the National Assembly, within 30 working days, refer His Excellency President Ramaphosa's violation of the Code of Ethical Conduct and Disclosure of Members' Interests for Assembly and Permanent Council members to the Joint Committee on Ethics and Members' Interests for consideration in terms of the provision of paragraph 10 of the code. Again, my emphasis there is that you could not yourself say, for example, that the President has breached the declaration codes and therefore he must be suspended from Parliament or whatever it is. That's not your province. Yours would be to send it to the appropriate structures of Parliament for consideration, as it says. Correct?
That is correct.
And if they find him guilty or not guilty, that's that's not your business. You would have then referred the matter to the appropriate structures. Correct?
That is correct.
Yes. Because again, that is something that is not well understood, I think, by many people. For example, in the CX report, I know you were not involved in that, that if you're recommending for Parliament to look into an amendment of a constitution or a statute or whatever, you are not prescribing if the consideration doesn't pass the 2/3 majority or whatever the prescript is, that's the end of it. You are out of it as the public protector. It is that institution that must then process the thing, correct?
That is correct.
Yes. That you, in the public protector, you are not mad people who can prescribe that the Constitution must be amended no matter what, whether it's 10% or 67%, doesn't matter. It must just be amended. That's yours is to propose, correct?
That is correct.
Right. Right. Then, just again to round off that, I won't read the other things about the members and publication of the donations received by the President. Oh yeah, no, let's read CC. You then said that within 30 working days of receipt of this report, the National Assembly Speaker must demand publication of all donations received by President Ramaphosa because, as the then Deputy President, he was bound to declare such financial interests into the members' registrable interest register in the spirit of accountability and transparency. Correct?
That is correct.
Okay, I've already made the point there. That's another referral there. And then coming to the issue of money laundering, the criminal activity, alleged criminal activity on the part of the President. This is, again, to confirm what you and I had discussed earlier. You said within 30 working days of receipt of this report, the National Director of Public Prosecutions is to take note of the observations contained in paragraph 17.3.1, as well as the recommendations contained in paragraph 77.3.3 of this report, and in line with section 64C, Roman 1 of the Public Protector Act, conduct further investigation into the prima facie evidence of money laundering as uncovered during my investigation and deal with it accordingly. Again, without sounding like a broken record, you couldn't find him guilty or take him to Hoshimampuru prison or anything like that. All you could do was to ask the NPA to investigate this further and either charge him or decide not to charge him or whatever, and the court to also convict him or acquit him or whatever. That would be out of your hands, correct?
That is correct.
And then lastly, you said the National Commissioner of the South African Police Services within 30 working days of receipt to investigate criminal conduct against Mr. Gavin Watson, the late Mr. Gavin Watson, for violation of Section 11.3 of the Public Protector Act by lying under oath. And that was in relation to the conflicting evidence, affidavit evidence of Mr. Watson as to exactly who he gave money to and how many people and how many candidates of the ANC had given money to, those kinds of issues, correct?
It is correct.
Right. Now, that's, I want, as I say, I'm just skimming through the report to get the highlights because we're not here to review the report. But the crucial issue I'm driving to is this. All these findings, recommendations, what have you, were they based on your conspiracy to get into Mr. Ramaphosa, or do you have anything against him, or were they based on the evidence before you?
They were based on the evidence available. Based on having the file on my left, on which all of this that we put in the report was was gleaned from. You know, we took it from the file.
Thank you.
Put it in the 7-9 in the report.
Thank you very much. And I'm glad you have it there. Well, you are lucky. The rest of South Africa don't have access to that file. It has been sealed. But be that as it may, the point I really wanted to make is that you, and I don't even want to know whether this is true or not, but you personally might be a big supporter of President Ramaphosa, and you might like him and be a member of the disease called Ramaphoria or whatever. But whether you like him or not personally, you would have to do your professional duty and follow the evidence, correct?
That is correct.
All right. All right. Now, let's then get to that big bundle that is sitting on your left there. And unfortunately, we can't, at this stage, deal with it in much detail. Some of the issues will be dealt with when the public protector testifies, which is around the corner. But for now, can you just confirm to this committee that particularly the email evidence, you were lucky enough to be provided with email evidence that showed the movements of the money in some minute detail, correct?
Yes.
Maybe not all the money that was donated, but you would have been able to see that there was 20 million rand, which was transferred by, I was going to say Mr. Chabalala, but he's not a billionaire. By somebody who's a big business person, and then that 20 million rand got into the account, and then half of it went to buy T-shirts, the other one to hire buses and all that. I'm just making it up, but you would be able to trace some of the money to that minute detail. Recipient, functions, date of distribution, and maybe another donation from the Mr. or Miss X. Is that a fair summary of the type of evidence that is contained in those emails on your left?
Yes, that is peanut information.
Yes. Right. And so this issue, which I said is very central, was central to this question as to whether President Ramaphosa, A, benefited personally, and B, knew of the movement of the money. The conclusions you reached, which we referred to earlier, were based on that evidence, correct?
That is correct.
Right. And more crucially, we'll come to the court judgment, because these proceedings here are mainly based on court judgments. The evidence showed not only that President Ramaphosa must have known about the money movements, but that some of the money, A, was even donated by him, so he obviously knew about that one. And also some of it went through his trust, correct?
That is correct.
All right. And some of the people you spoke to included the people, there's somebody who plays a role called Mr. Bejani Chauke, who was doubling up first as Mr. Ramaphosa's advisor in his presidential office by day, but at other times he was the chairperson or manager, quote unquote, of the CR17 campaign, correct?
I think if I may correct you, we met with campaign managers, and he was one of them.
Yes, yes. No, I understand that. You met him in that capacity as a campaign manager, but I'm saying then and now he is also, or even in this documentation, he was described as Mr. Ramaphosa's advisor. In other words, in his government capacity. You may not have known that, yes, but he was, let's just, for your purposes, he was described as his advisor, correct?